What I want to talk about today in a few minutes is common mistakes that we at Rudner Law are seeing. Many of them are on the side of the employer, but some are employees as well. Tips that we often give our clients. I'll share some with you now. Employers seem to confuse investigations with prosecutions, and it's almost uncanny. I'll have an employer client call me and they'll say, we believe that an employee is guilty of such and such misconduct. Maybe it's harassment, maybe it's theft, whatever the case may be. And they want to fire the employee. And say, I will talk them down, explain to them that in Canada, there is a duty of due process. You're going to look really bad if you fire them without investigating, and in particular, without giving them the chance to respond to the allegations. Perhaps they'll have a credible explanation. Perhaps they won't. Perhaps they'll actually compound the situation by acting in a dishonest manner, which will give you more cost to fire them. But you need to investigate first. So when I explain that, the response I often get is, great, we'll investigate, gather the evidence we need so we can fire them. That's called a prosecution. So this is a mistake I see very often. People need to understand that if you're going to investigate, it must be done fairly, objectively, and of course in a timely manner and thoroughly. But people need to understand investigation is objective, not prosecutorial. So that's one common mistake we make. Another one is bad policies. I see so many policies out there that I think are drafted with good intentions, but they will say things like, if we receive a complaint of harassment or sexual harassment, it will be investigated within 3 business days. You can't promise that. There are situations where you'll be able to do it. There are many situations where you won't be able to do it. Or I've seen some where it'll say things like, it'll be investigated by the director of HR. Well, perhaps the director of HR is on vacation or on leave or just really busy. Or it's one that should be investigated by someone external, like a private investigator like Axis Geffen, who I interviewed recently on episode 5 of Fire Away. Either way, you don't want to promise who's going to do it, how long it's going to take. The other thing that I see all too often, people want to encourage employees to come forward with complaints of harassment, and for good reason. You want to make sure people are comfortable doing so. However, I've seen too many policies that say, if you bring forward a complaint of harassment, you will not face reprisal, period. Sounds great. Problem with that is, what if it is a false, malicious allegation made in bad faith? Then you want to be able to impose discipline. And this is where someone like, again, Axis Geffen, who I interviewed in episode 5, will go through an investigation and reach a conclusion. And I've seen it happen. I'm not saying it happens often. Most people who complain of harassment or sexual harassment do so in good faith. But I have seen situations where people, for whatever reason, decide the best way, for example, to get rid of their manager is to accuse them of sexual harassment. And if that's the case, then they should be subject to discipline. So be careful. You can make it very clear there will be no repercussions for a good faith complaint, but otherwise there may be repercussions. Failure to train. If you have a policy which says that all allegations of harassment will be investigated, which you should have, make sure your managers and your supervisors know about this. And I've seen cases where individuals go to their supervisors and say, I just want to tell you about comments that one of my colleagues are making, but I don't want you to do anything about it. And often you'll have supervisors who want to be gentlemanly, if it's a gentleman, and respect the wishes of the individual, and they don't investigate. And of course, that's not only a breach of Bill 132 in Ontario, it's something that will lead to more liability on behalf of the employer. So make sure your managers, your supervisors know what your policy says and of their duties. Bad processes are another common mistake. In other words, you need to have a reporting mechanism, and Bill 132 requires this. How do people report allegations or concerns of harassment? And Bill 132 actually did something very smart. This was long before Harvey Weinstein. They required essentially a backup reporting mechanism. So if the person's harasser is their boss or is the owner of the company or the star of the company, where else can they go? Is there a backup? If it's not HR, who can they turn to file the complaint? So they don't feel as though their complaint won't go anywhere because they're going to have to go to the person who's actually harassing them. So that's a process. Also not documenting things properly. If you're going to investigate, if you receive a complaint, document your investigation, document the conclusion, document the results. If there is any action taken, make sure all of that is documented very clearly so that 6 months from now, 2 years from now, 10 years from now, you'll have a record of that if something else happens. So that's very briefly common mistakes we see made by employers. On the employee side, there aren't as many mistakes. One is just failure to complain. If you're being harassed, sexually or otherwise, raise this as soon as you can with HR, or if there is some other mechanism in place, raise it. You can't just endure it, and then when it becomes too much, call your lawyer and threaten to sue. You need to make sure the employer has a reasonable chance to address it, especially if it's a larger organization where the powers that be may not be aware of the harassment. You need to tell them about it and give them the chance to respond. If they don't, you'll have an even stronger complaint down the road. But you need to make that complaint as soon as it starts happening. Don't assume it's going to get better, because it almost never does. And the other common mistake that I see employees making is dishonesty. Either lying in the investigation, which any professional investigator will tell you that more often than not they will be able to tell when you're lying, or it will come out because there will be evidence that will disprove what you're saying, or telling other people to lie, discouraging witnesses from being part of it, or even threatening witnesses. That's a common mistake. Or refusing to participate. If you've made a complaint of harassment and then you refuse to participate in the investigation, you are really just hindering your own cause. If you want it to be dealt with properly, you've got to take part in the process and give your employer a fair chance to deal with it. Otherwise, you really can't complain if you don't get the result you want. So that's my 2 cents worth, and you got it here for free.